certainly to the best of their ability to do so. Mr. Behal, to the extent that he can, tried both with law enforcement and in the courtroom setting. And obviously we don't have the opportunity to hear from Ms. Escontrias, and there's certainly no recording. So there's all this gray space. But I always have to be a little bit critical about expectations. And maybe my expectations are unfair. That's fine. I can live with that. But your expectations matter, and I just want to bring that at least to your attention with respect to these things, because I'm always looking for not only what can they prove, but what should they have proved, or like where should they have looked, just to give us the fullest version of events. And maybe these are questions that you don't inherently ask, but certainly questions that I do. And I would submit to you that after Christopher Behal started talking to law enforcement, after he gave the second statement, that being to now Deputy Rolling, at the time Detective Rolling, they stopped investigating. That was it. They had their guy. There was no need for any further investigation, any attempt to answer questions, to understand what took place within those four walls at 105 Crestview, I believe it was apartment 4. Now they presented you DNA, which was done after the fact, but I'll submit to you it's done in almost every case. And I'd submit to you that it wouldn't matter what that DNA came back and said. He was getting prosecuted for this offense, and they were going to make similar, if not identical, arguments to the ones that they've given you already. That is just kind of something where it looks scientific-y. It can be impressive, something you may see on television. But it's not presenting you anything you didn't already know. You'd suspect to find her blood in her apartment. It's where she lives, that's where she was, the blood was there, you've seen the photographs. There's not really any question about that. What are other things that I think are absent? And again, if you heard differently, go with your gut, go with your own notes. But I think it could have been a useful tool to get text messages from all involved. At least they presented messaging app information, but no text messages from either Taylor or Mr. Behal. It sounded like there was an issue with maybe the passcode for Mr. Behal's phone. I believe they got it, but it was inaccurate. But that doesn't stop law enforcement. They can subpoena those documents. There's other means to get phone information, and I think it could have been useful just to illustrate whether or not there was a tone, specific language that was used, any topics of conversation, just to sort of understand, is this something that had been building? Is this spontaneous? Is this new? Kind of what is the status of their relationship? What else was absent? Certainly a reconstructionist or any expert that could tell you what happened inside of that apartment complex. And then any investigation of events prior. Obviously, the idea just being, and I think I talked to certainly one of the law enforcement, I want to say it's Rolling, but forgive me if I'm mistaken about that, about sort of the plasma, about any of the stops they made, just to try to figure out, is there a consistency or is there an inconsistency with like his recall the entire day, kind of just to figure out what they should and shouldn't believe, right? But they didn't present that to you. And I submit to you, to the degree that they think they know what happened in there, I think the less credible they come off, or at least I submit to you that's the case. Because they just don't have anyone who can testify definitively to those things. I think, and it's almost always my opinion, that police officers try to do the best they can, to the extent that they're capable. I think that Deputy Grease and Deputy Rolling are very likely good cops, and I take no issue with that. What I don't think, though, is that they're experts. And I think to the degree that they try to submit to you something they know that happened inside this apartment, they simply do not. And I think my argument is supported at least by the testimony of the officers themselves. So Deputy Grease, I believe, had, I guess I'm not even sure if he had a degree from a college institution. Not necessary, but again, didn't have one. No master's, no PhD, no scientific, I guess, related undergrad or degree program. He was law enforcement trained throughout the entirety. He didn't conduct, at least as I'm aware, any experiments to, I guess, kind of confirm or reject any conclusions he may or may not make. So I think that's a deficiency, at least in the state's case. I also think that Deputy Rowling had an exhaustive resume about every digital forensics class that he took, and I believe there may have been one interrogation course in there, but nothing that would make him ideal for investigating a crime of this type. And I'm sure that there's probably other officers on duty who could, or certainly other experts the state has access to that may, but those were not used because, again, there was no need for them to do so, right? They deduced already that they had their guy, and the explanations didn't matter so much at that time. So let's talk about the messenger apps. I submit that this is not foreshadowing. I submit to you, at least at the time that these text messages are sent, there is no ongoing crime. And I submit it to you based on, again, reason and common sense. So I want to talk to you about a few things. So first of all, I think the timing is significant. The first text message, at least that they offered, was sent to Nick Seaman. I think it was 11:34 p.m. I think 11:35, if I'm not mistaken, is when Mr. Holland reached out to Taylor that evening. So first it's something to the effect like, if something happens to me, Chris did it, right? Which seems like something's escalating, right? Something serious going on at that particular time. But then Holland reaches out with a, hey, how you doing, or something to that effect. It's very casual in nature. There's no other interaction with Seaman other than that, because I believe the testimony was he was asleep, so he's not answering or responding. But there is a significant drop-off from, if something happens to me, it's Chris, and then just kind of, how are things, what's going on, and very casual in nature, which is suggestive to me that if it were serious and ongoing, she wouldn't be texting him back, and if she was, she'd be saying, get here immediately, something, like just some indicator that like he's losing control. So I think there's significance to that. I think what stands out also is the fact that she's able to call and text. Again, if she was, if it just went radio silent, I think it'd be more suggestive that at that point in time something's going on. But she's able at least to call and text. And there were 2 calls, I believe, placed to Mr. Holland. Maybe they were incoming, maybe they were outgoing. I don't remember specifically. But what was the takeaway for me is that both times Holland said that there was no background noise. So again, it's indicative to me, if you're using common sense and experience, that there's not an ongoing assault at this point in time. If there was, he would have heard it. Either he would have heard it in her voice, or he would have heard Behal in the background, none of which he testified to. We know that she didn't call or text 911, which is not a requirement, but certainly a little unusual. Perhaps, again, if you feel that your life is in danger, you're not texting someone you used to hang out with, you text the police. Or you just leave the apartment complex. And again, we know that at least the time that she's communicating with Holland from beginning to end, and I don't remember exactly how much time that took, but certainly she's not fighting with him then, so just leave. Which again suggests kind of the unseriousness of the text messages that she's sending out. It suggests to me, just like both of them testified, this is just how she talks sometimes. I think Holland said on numerous occasions he's gotten calls or texts just like this about various historical boyfriends that suggests this is just the way that she communicates. This is the way in which she acts. I think he said particularly when she's under the influence, which we know she was because her blood alcohol content was greater than 300 when she passed away. And we know that neither one of them took it seriously enough to take action. We know that because Holland, I don't think, ever communicated with a law enforcement entity other than obviously to produce his messenger app, and I think that was long after the investigation had started. And then Seaman, I believe, did reach out to law enforcement, but it was after first seeing some indicator on like a Facebook page or some outreach by law enforcement saying, hey, does anybody know anything? And he replied at that point, but certainly didn't make any effort to do that on his own. The message deletions, obviously it's been raised. I think even Mr. Larson indicated he's not sure who deleted those messages. I submit to you it was her. It was Taylor Escontrias. And I don't think it's like for a nefarious purpose, but I don't believe, or I submit to you, certainly, that it was not Mr. Behal. And why I say that is because if it were Behal, would it make sense to delete more than is necessary, A, and B, would it not make sense to delete any text messages with Holland that were similar in nature? Like, why delete partial texts, including innocuous texts about a liver, or like a fucked up liver, I think is the terminology that was used. Read the exhibit for yourself. And then something about making a doctor's appointment. Those just, it wouldn't be useful. Like, I don't know what he would be trying to hide at that point. But it does seem useful if, you know, it's a girl who's maybe just embarrassed about still communicating with an ex, maybe afraid it might make her boyfriend uncomfortable, and she's just deleting them, kind of cleaning it up as they're coming in. That makes certainly more sense when you consider reason and common sense than he's destroying evidence but then leaving a bunch of it behind. They hit the phone. I just threw it on there because Brett addressed it. Obviously, I take issue with that because the phone's not hid. The phone's in the house. It's in the apartment, as is virtually everything else, right? Screwdriver's in there. Knife is not. The bat is. The blood is. Taylor Escontrias is. Defendant lives there. It's just a weird call to be like, well, that's the outlier, right? He hit the phone in the apartment under some sheets like a child hiding from a monster. Count 2. This is the only point in time I'm going to address it, and I'm going to be swift. It's factually inconsistent. Count 2 talks about a domestic assault, but then at the same time, on the other side of the mouth, we're talking about a death. They're just inconsistent factually, and that's all I'm going to say on the matter. So count 2 is factually inconsistent. Murder 1, as I submitted to you already, is not a viable conclusion to reach. I take issue, obviously, with all the instructions, but I'm going to hyper-focus for purposes of this marshalling instruction, and it's going to be the portions of it that are in bold. So, defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Taylor Escontrias. And it's been defined, again, the instructions are exhaustive, but I'm going to just highlight a few. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Now, that can happen by instruction in almost an instant, but it is still something you have to consider first. So there at least has to be some time span in order for you to consider what you are going to do next. Premeditate is to think or ponder upon a matter before acting. So very similar in nature, but I'd submit to you that is certainly the opposite of a reflex. Right? A reflex, you're not doing those things. You're not thinking, you're not pondering, you're acting. So again, those just stand out to me. Malice, again, just a portion of the full instruction, requires only such deliberation that would make make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. And heat of passion, if you don't recall, is also language in the voluntary manslaughter instruction, and we'll get to that. But that's contemplated in the definition of malice that's offered. So I just want you to think of just an activity. Any activity. Doesn't matter what it is. And the question is like, once you're in it, are you just in it? Like, are you just doing it? Or are you kind of like, are you considering, are you then contemplating and recontemplating every step in that process? We'll treat it like a walk in the park, right? Are you contemplating each step, or did you contemplate the walk and then every step is not being deliberated and is not being premeditated? That is just happening. That is in the action that you're already in. Another example is just eating food, each bite. Are you contemplating each time, or are you just doing? Pedaling a bike, same idea as walking. Each step, are you contemplating, are you premeditating, or are you simply doing? So premeditation, if you're going to plan a murder, is this how you do it? This is how anybody would do it. I think the act itself, I think the evidence that the state has presented is illustrative to me. I just butchered that word, but I think you know what I'm saying, that there wasn't a plan. I think in essence it indicates the complete absence of one. because nothing makes any sense if it were planned first. For starters, what would we assume would be evidence? And again, this is where common sense and reason comes into play. There's no like textbook or testimony, certainly, that illustrates these are the things that are required for premeditation. That's simply not the case, but these are things you can consider when you're considering the evidence. Things that might be evidence of premeditation. Things like journal entries. And maybe not everybody keeps a journal. Maybe they just keep it like, I keep my notes in like a notes app on my phone. It's kind of like my thoughts. It's not an everyday journal, but just an indicator of my thoughts. Maybe it's text data, which is in many ways absent here. We do have messenger app data. We don't have any text data that, at least as far as I can recall. Google searches sometimes can be useful. We actually see them all the time on like crime documentaries and stuff, if any of you watch those. They'll just go back through the suspect's Google history and look for things that are indicative of how to kill a person, how to hide a body, where to buy a gun, if it's a shoot, things like that. Some indicator that this is planned or premeditated in advance, and that is absent from this case. Any statements to others. So again, like talking to a mom, a dad, a cousin, a friend, a confidant, anyone at all that comes in and says, hey, he's been losing his shit for a while. This is what he's been talking about. I didn't take it seriously. I didn't think you'd do it, but here we are. Those are things that would be indicators of deliberation. And I think a weapon purchase, the next part on there just kind of talks about implements of convenience. Just so you know what I'm talking about, they're not things that wouldn't be found inside the home. In fact, these were things that would be found inside the home, not things that were like special purchases, like things that I went out to do. Like if I'm going to bury a body, maybe I go out and buy gloves and a shovel the day before, or even moments before. Some purchase indicating what act is to follow. No destruction of evidence. And I think that there's some debate between the parties about whether there was or wasn't destruction of evidence. I submit to you that there was not. To the degree he had the knife outside of the apartment, it was in the car next to him. I wouldn't necessarily define that as destruction of evidence. There's no use of water in the bathroom or kitchen. Maybe you didn't notice, maybe it doesn't mean anything to you, but certainly like a shower, an attempt to clean hands, an attempt to clean up the apartment, like those would be indicators of destruction of evidence. There's no testimony that he changed his clothes. I think even the shirt that he was wearing at the time law enforcement took possession of him, or at least took his clothes from the hospital. He had a knife wound, or at least a wound consistent, strike that. He had a cut on his shirt consistent with a knife wound, which is an indicator that he kept the same clothes on. And he did leave. That was something that was brought up in closing statements by the state. I just want to say, if that does go to state of mind, and we'll get to state of mind in a moment, but if it does, just bear in mind it's the same state of mind that resulted in a vehicular accident with a non-moving entity, right? I think it was a concrete barrier around a lighting assembly. And that just seems inconsistent, I guess. This is more of the same, just didn't change clothes, didn't look for a weapon. I think that there's evidence to support if he changed clothes or was looking for a weapon, he would have tracked blood into the bedroom. Either his own blood, and we know he was bleeding because there's been testimony that he was actively bleeding from his abdomen, it was on his shorts and on his feet, or it would have been her blood, Taylor Escontrias' blood. Now this is just one image, one perspective, but there were various perspectives of that room, none of which show blood in that particular bedroom. More of the same. In the middle is bedroom 2. Again, it's just one perspective. There were multiple photos taken to cover the entire room, and there's no blood in there either. There was no blood in the hallway, which is indicated on the image to the right, which shows into the bathroom, I believe from bedroom 1, but don't quote me on that. And then the image to the left is the bathroom, which again, just showing that it was not used. I did not present a picture of the kitchen. The kitchen shows blood, obviously. We've seen it. It's right in front of the refrigerator, but the blood stops at a particular point, and there's no tracking to the sink. Now, there is a screwdriver there. I don't know how to explain that, to be honest with you. I don't know who put it there. Maybe it was moved by law enforcement just to get it out of the way. I don't know what it was, but the sink in that particular room in the kitchen was dry, as was, there was a like a sponge on the left of the sink, and it was like curved up. Any of you who have sponges on the side of your sink, they kind of curve as they dry out. So we know that it was at least dry for some time. So the kitchen sink was not utilized either. Intoxication. The defendant claims he was under the influence of intoxicants at the time of the alleged crime. Now, intoxication is a defense only when it causes a mental disability which makes the person incapable of forming the specific intent. Again, unfortunately, some of these instructions, that is what they provide. You kind of have to make sense of them on your own. Some of these instructions necessarily don't always make perfect sense, but try to use, again, your common sense, your ordinary usage of terms, etc. Signs of impairment, just in general, these are things that were kind of, I think this is a conglomeration of different things that were said at different times throughout the trial. Some of them may just be reason and common sense, certainly things you may have seen historically. Those are slow or fast speech, which was present in Mr. Behal, the slow speech. I don't believe there was any fast. Difficulty finding words, speaking incoherently. I think it was Officer Leonard said that when he got there, he couldn't even make out half of what Mr. Behal was saying because he was incoherent. He issues of balance, I don't think we've seen. He was strapped to a board. I don't think he was really walking, at least at any point that we saw by way of evidence. Behavior can be altered, crying or moody, red watery eyes, lack of eye focus, smell of alcohol on a person, and blackouts. So some, if not many of these were present. Some of these were absent for various reasons, but certainly all signs of impairment. So again, even if you have a tolerance, if you're exercising impairment, which I submit there's evidence to show, then you know your tolerance only goes so far, right? Like you're still under the influence, and you're still feeling the alterations. What's the word I'm looking for? Just kind of your altered consciousness. Evidence of Behal's intoxication. Some of these we already addressed. Some of them is memory. It's referred to as a blackout. I believe that was a testimony by Dr. Boyle this morning. It is not saying that things did or didn't happen. It's simply saying you don't necessarily recall just because of the way that the memory is created, like sort of the transfer of information across the neurons. So recall is not an element. And I think Mr. Larson had already broached on that, and I'm not here to tell you otherwise. Recall is not an element the state is burdened with proving. However, it does bear the question, or beg the question, forgive me, that if you're losing your memory, what other portions of your brain, what other functions are you losing? It strikes me as odd that part of your brain isn't functioning, but the rest of it, the remainder of it, is working with perfect function. And I submit to you that sobering up doesn't give that back. And I believe that was a testimony of Dr. Doyle, but I just ask you again to exercise reason and common sense. Maybe some of you have had a night where there's gaps, and I guess ask yourselves, frankly, do you get that memory back? And I submit to you that you don't. Further evidence of Behal's intoxication is the single vehicle accident. It certainly wasn't caused by someone else. It was his own operation of the motor vehicle. And there was no alcohol in the car because we know he already drank at the apartment. The bottle was found there. The testimony is consistent with that. I don't think that that's really an issue. But just to be clear, he didn't drink in the car after he'd stopped. He was already under the influence of alcohol. There was slurring. There was vertical gaze nystagmus. And the only reason that that's there is to, again, be an indicator. I don't recall which law enforcement officer testified to that, but he said that horizontal gaze is one useful tool for them, and that vertical gaze nystagmus is an indicator of like extreme impairment. That was my recall of his testimony. So he uses horizontal, I think, as kind of a baseline, but then he also uses vertical to see how bad off the particular subject is. And he said that vertical gaze nystagmus was present as an indicator of extreme intoxication. We know the empty gallon of vodka, and we know that his blood alcohol content was confirmed by the hospital as being well over 300. This is kind of, again, a conglomeration of both Leonard and Doyle's. The useful portion from my perspective with respect to Mr. Leonard's testimony or Officer Leonard's testimony is he's an OWI instructor. So at least with respect to the intox, he's well versed, he teaches it himself. I think he said he's like a field training officer, but forgive me if that's not correct. So he has a ton of experience. I think 17 plus years law enforcement experience. And he said himself that over 300 blood alcohol content is very high. And he said that in his personal opinion, or at least in his experience, anyone over 300 is generally not even awake. They're unconscious. They're rendered unconscious by the amount of alcohol. And he said even with extreme tolerance, which was a question that was posed, like, what would that look like? And he said that they'd still be impaired, but they'd be awake. So they'd be up and about, but they'd still be very impaired. So even with an extreme tolerance, according to Officer Leonard, it'd still be impaired. And it impacts a person's ability to understand and to comprehend. I just want to touch on the Jekyll-Hyde thing. It came up during Dr. Doyle's testimony. I don't remember what the question was that it was in response to, but he says, like, some people, I'm sure you're all familiar with the story of Dr. Jekyll and Mr. Hyde. It's basically like I think he was we'll call him a scientist for lack of better words. And he created like a tonic or a potion that when he took it, he became like his alter ego. He was this large man, very strong, very, I think, angry and violent. That's the premise behind that. It just says that, at least the PowerPoint says, there's no evidence or indicators that he exhibited that type of behavior, at least not anything that's been offered by the state. And I don't think that there's any physical evidence to support that, and certainly you could see that differently. But what I'm getting at is, we know he's an avid drinker. We know he drinks all the time. There's been testimony offered to that. If he was freaking out every time, wouldn't there be like destruction of like stuff within the unit, right? Like, wouldn't the apartment be just in disrepair because every time he freaks out, he's putting his fist through walls or kicking doors or just destroying the property? That seems to be indicative of a Jekyll and Hyde behavior, which is not exhibited here. I submit to you what he offered law enforcement was not a confession. And there may be variance on what a confession is, even to you. But at least in just layman's terms, it's an acknowledgement of guilt. And that is not what I saw or heard in the evidence. Again, I'm not a fact finder. That's not my job. But what I heard is simply a man trying to figure out what the hell just happened. He has these moments in time, these flashes, these snapshots. I think snapshots, not videos, was the reference by Dr. Doyle. But he has these images he can't shake. He's got this, he's seeing these things happen in his mind that he himself doesn't feel himself capable of, that isn't making sense, that he doesn't think could possibly be true. But these are the versions he's given up based on these images that just are flooding his mind. The term that was interesting to me, a term I'm not familiar with, I hadn't heard before, but I think I've used in like a different way perhaps, is confabulation. Basically, what it reminds me of, some of you may remember this, some of you may not. I think there was this thing on Facebook, and I think it was actually a real study. It was like an Oxford study about sort of how our brains work. And if I recall correctly, they would take the first letter and the last letter of various words in this paragraph, and they just mix up all the letters in between. And basically what they found is some people can read that and their minds will correct all the letters and they can read it perfectly. And some people, their brains won't allow them to do that, so they can't interpret that script. This is kind of, I think, similar to confabulation, which is basically your brain doesn't like the gaps. It doesn't like the errors, so it fixes them. And what it does is it forces them, you imply your own form of logic to fill in the gaps. And I submit to you, that's what he's doing. He's got these flashes, and he's trying to fill in the gaps, and he's trying to give the law enforcement some explanation. Now, the video is long. I'm not going to play it for you. Thankfully, neither did the state, but you'll have access to it if you want to watch it. There's obviously a lot of significance to the video. There's a ton of stuff being said. I think that there's also some significance to the gaps. And the gaps I'm referring to are the times in which Deputy Rowling was not present. And he was talking to himself. And these are exact quotes. He says, "What the fuck? The fuck did I do? I fucking loved her. Fucking drinking has ruined my entire life. I don't know why I would have ever fucking killed her. It should have been me, not her. Why did this happen? I really hope," forgive me, I'm paraphrasing, "this was just a dream. Really just wake up at any point." And then you actually see him close his eyes and he opens them again. He says, "Wake up." And I just want you to at least remember those as an indicator, again, from my perspective, that he just is trying like hell to figure it out. And I submit to you that they're genuine. I haven't heard the state say it. Maybe they will, maybe they won't, that he's making all this up. But it just doesn't make sense, right? Like, what's the value in telling them all this stuff but then also faking it, right? Like, what exactly is he leaving out that he's capable of giving them? And I think that it's consistent with every person that he spoke to, at every time that he was spoken to. The hospital, he had no requirement to speak, guys. He didn't have to say a word. He's not required to. He can't be forced to. But he asked law enforcement specifically to turn off the beeping in the room so we could just have a conversation with the officer. And he asked that officer to check on Taylor. At that point in time, he knew something was wrong. He had these flashes in his head that he couldn't make sense of. And he's like, "Please go check on her." And that's what triggered law enforcement to start doing those wellness checks that night. They didn't do it on their own. There wasn't a 911 call placed. He directed them, "Call my girlfriend. Check on my girlfriend." At the interrogation room, it is very evident he's trying to figure it out in real time. And even the parts where he's like, "No, that doesn't make sense," he would start over. I see it differently from the state, I believe, with respect to, he's not saying he made it, he said he made it up. But I think it's all, at least in some degree, made up. He's saying what he saw in his own mind, but he doesn't know the whole story, and he's trying to fill in the blanks, and he's giving them the information that makes logical sense to him. But he's clearly trying to answer the officer's question. Even the officer admitted, "I didn't interrogate him. He's just talking." This was just a casual conversation, and he's talking to the officer. And I think it's significant that he doesn't acknowledge the camera even a single time. If he's playing this up, which is an incredibly long game that honestly doesn't make any sense to me, but if he's playing this up, he's both the best and the worst actor I've ever seen. I don't understand sort of all the information he gave to then also be faking the rest. It's like believe part, ignore part. I have a hard time logically following that type of thing. And just bear in mind, no one's looking for her at this point. And why is that relevant? It's just relevant to, again, the genuine nature of it, because he could have very easily just been processed for his OWI and gone home. He started everything. He gave law enforcement a reason to go looking for Taylor Escontrias. Holland, Seaman, nobody reached out to law enforcement. They weren't looking for him at all. Murder 2. Now this is, again, what I believe is the ceiling. Murder 2 is the ceiling here. And what's relevant, and forgive me, the second bullet point, it says in element 1. I just didn't want to be incredibly redundant, but you have the marshalling instructions. The activity in element 1 it's referring to is the screwdriver, knife, and the bat. Okay? So I think we're on the same page there. And again, I just submit to you that there's insufficient evidence to conclude the planning, the premeditating, the deliberation that is required, particularly in light of his intoxication level and the evidence we've seen about that. Voluntary manslaughter. This is the floor. So the two options as I see them, and I submit to you. Voluntary manslaughter. Now again, I'm not conceding elements, but I am focusing on the bold script. And it says, stabbing and or hitting of Taylor Escontrias was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. And I have to imagine this hasn't been something you guys have been thinking about, probably at least first and foremost because you didn't know the jury instruction, which you just got, I don't know, an hour and a half ago. But this is something I want you to seriously consider, and I'll explain to you why. So serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under these circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Now, passion is not defined, so you have to use your ordinary common usage in that endeavor. Now, did he act with provocation? I submit to you he did, and I'll explain to you why here in a moment. But do not conflate this with justification. This is not a justification defense. That is not what I'm offering you here. Justification is self-defense. That is not what's been offered by the defense. There's requirements in order to provide evidence of such. It's not there. We're not saying this is justification. We are saying that this is provocation. Now, I submit to you Taylor Escontrias stabbed Christopher Behal in the gut. Now, it begs the question, what's more provoking than that? And I struggled very, very hard the last kind of day or so to think of a scenario that I thought would be more provoking in nature than being stabbed with a knife in the abdomen. The only thing I could come to, but I have no real life experience about it, is like threatening my children. I don't know shy of that, and maybe, obviously my wife, but really my kids, right? That's my job, is to protect my children. If someone threatened my children, that would set me off more than anything in this entire world. That would be provoking in nature. That would cause me to act. There's no question about it. But what's next in line? Now, we're not talking about sort of the metaphorical concept of stabbing me in the back, right? Like doing something nefarious to me that sort of breaks our relationship or what have you, our trust that we may have developed. But this is someone you love. It's the equivalent of a person's wife, right? At least for purposes of their relationship, that's kind of the way he thinks of it, I believe. And that person either looking you in the face or not and taking a knife and plunging it into your abdomen. And I ask you, what is more provoking than that, other than the things we've just described? And I submit to you that the evidence bears this out. First of all, he has the injury. There's no contesting he has the injury. And I submit to you that this happened first. Now, how do I come to that conclusion? Just with reason and common sense. I'm not an expert. I'm not a reconstructionist. I don't play one on TV. But there's no blood on the kitchen cabinet where the sheath was located. Now, I believe the testimony was that was essentially the knife in the kitchen. They didn't have a cutting block. I think Deputy Rolling said that there wasn't one there, but at least someone did. There was not a knife block. That was the knife that was in the kitchen. And there was no blood on it. So she wasn't bleeding. So at this point, there couldn't have been an attack. And the reason I say that is because we know that she was bleeding everywhere, right? We know that there was a ton of blood lost. So we know she's not bleeding when she reached for that knife. So it had to have happened first. We know that she, at least I submit to you, she couldn't have disarmed him. At what point? She's bleeding. She's drunk. She's injured. She's, I'm assuming, smaller than him, although I guess there's no testimony that's been offered to illustrate that. And we know that he's bleeding because there's a mixture of blood in the apartment. So it didn't happen at some later time. It happened in the apartment. And again, the only logical conclusion is that she stabbed him first. Excess. What do I mean? I mean like an overreaction. I don't know. I didn't really know what a better word would be to use for that. And I just want you to think about a time that you've acted in excess. See, I can't even read my own PowerPoint. Just, was there ever a time, a moment? And then I want you to think about, did those circumstances matter? Like, was there an emotional component that fueled that acting in excess? And I just kind of think about, again, my own personal experience and the one time that I acted in excess. And it wasn't to this degree. It wasn't, nobody was charged, anything like that. And it was a stupid, juvenile, it was a bar fight. And there was an incident with a girl that I was dating at the time, and this guy just acted untoward in a way that was, there was a lot of history that led to that, so it wasn't just a one-off. But we were at a bar, and he made the first move, and he hit me. And we fought. And I ended up on top, and I was probably there for much too long, to be honest with you. And friends and bar members grabbed me and pulled me off and dragged me out of the bar. And I was angry. I was embarrassed. I'm still embarrassed. I've never been dragged out of a place before. But I would describe that as an acting in excess. But I would not have reacted that way. In fact, I've never reacted in that way since, but for the emotional component. That this was involving a girl that I was young, and when you're young, you think they're all the one. So it mattered a lot to me, and I acted in excess. But I submit to you that people don't generally act that way when there's not an emotional component involved. Again, that's just my position. I submit to you that there's no evidence of self-harm. So any idea that he did it to himself is frankly laughable. How do I come to that conclusion? First of all, there's been no evidence that he's a cutter. Some of you may be familiar with what that term means. Some of you may not be. But if you are familiar with someone who cuts, think about where they generally cut themselves. Those are relatively superficial areas, usually areas that are easy to hide because they don't want others to know about it. They're not generally cutting life-threatening vessels or life-threatening areas of the body. Those people are suicidal. Cutters act out of depression, agony, self-loathing, things of that type. And we know that it was a stab, not a cut, because it was described as such. The expert, Klein, described it as a stab. He said the difference is if it's deeper than it is wide, then it's a stab. If it's wider than it is deep, it's a laceration or a cut. So this is definitively a stab. It was 2 to 4 inches deep, according to, I think it was Officer Raby, and 1 to 1.5 inches wide. The laceration observed on, the stab observed on Mr. Behal's, again, it was described as kind of his waist, gut, abdomen, that area. We know that it was not caused by the car accident, and we heard Officer, I believe, Leonard, who testified to that he'd inspected the interior and didn't conclude that there were any sharp jutting pieces of plastic or metal that could have resulted in that injury. And we know Behal's right-handed. Again, not an expert. Don't play one on TV. But I am armed with reason and common sense. And think about if you stabbed yourself where you do it. It would be on the right side of your body. It wouldn't be on the left. It doesn't make sense. People don't stab across their body. Again, I'm assuming none of you have ever stabbed yourself on purpose, but if you've ever stabbed yourself on accident, your right arm doesn't generally go across your body. Now, if you were stabbed by a right-handed person, it would be on your left, which is consistent with where his injury was located. That was not done by Mr. Behal. That was done by Taylor Escontrias. Now, this is the part that sucks to talk about. I just use We're Going on a Bear Hunt. I don't know if any of you have ever read that book. I think it was from the late 70s, early 80s. And as with every children's book, there's a moral to the story or some lesson that they're trying to teach you. This is just a story about a family that are just going on a bear hunt, right? It's a fictitious bear hunt. They're taking a walk, really, is what they're doing. And they come to different points, different obstacles. They're meeting adversity in different ways. And really the moral of the story is essentially when you reach adversity, sometimes there's no way to do it, to go through it, but to just go through it. Sort of the idea that you can't go around adversity or under. You just got to kind of, drop your head and just go. You're just going through it. So I'm going to present to you what is the defense theory. And it is just that, a theory. But I believe when you exercise reason and common sense, you can reach many, if not all, of the same conclusions. I think in many ways what the state has offered you so far is really just state's theory. They just don't call it that. That's fine. On the right is Exhibit 49. That was a diagram that was drawn by Officer Grease, or Greasy, I'm not sure, I might be messing his name all up. The image on the right is just, I guess, to give you an idea of where things are taking place. I submit to you the incident begins in the kitchen. I submit that to you based on the copious volumes of blood that were found there. It just doesn't make sense, again, why would the blood be there if not that that's where the incident started? I submit to you it's at this point in time, they're having a discussion, maybe a fight, who knows. Taylor stabs Behal in the abdomen. And I submit to you that there's no scenario that supports that this happened later in time. And we know, again, implements of convenience. We know that the screwdrivers were kept in the kitchen. We know that the knife was kept in the kitchen. We know that the bat was kept somewhere in the apartment. I don't think that there was any definitive testimony about where the bat was, but they were all, I submit to you, within a small area within that apartment. And again, the reason I say it is because there's no blood trails in B1, B2, or the bathroom, or the hallway. So everything that was grabbed at any point in time during this incident had to have been within this kitchen right in front of the fridge to the living room. That's what at least I believe the evidence shows. We know that, again, he's bleeding, so he's not bleeding in B1, B2 in the bathroom, so there's no evidence that he went there. Now, it's my theory, it's our theory, that she stabbed him and he hit her. I don't know with what. I think sense makes that it was with the baseball bat, but that it was instant. It was a reflex. I got stabbed, I have an impulse, I strike her. Now, why do I come to that conclusion? I submit to you that any person struck in the head with a baseball bat is probably rendered immediately unconscious. There's not been any testimony, expert testimony to that, but again, use your reason and common sense. And not only is she, the skull's just not made to withstand that type of force, but she's also under the influence of alcohol, and I submit to you she goes down. It's one hit, it's likely to the front, she goes to the ground. I submit to you when she hits the ground, she fractures her jaw. Dr. Klein testified that a fall from standing could fracture your mandible. And at least with respect to the x-ray, I didn't see, again, I'm not an expert, but it is reasonable that she fell and broke her jaw in that moment. And I submit she never regained consciousness. I don't know if it was from the bat. I don't know if it was from the alcohol. I don't know if it was from a combination of factors. But she goes down and she doesn't regain. And the reason I submit to you that that's the case is because all of her injuries were to her back. At least almost all of them. Which means she's already down, likely out, likely unconscious. If she were fighting or if there was an elongated incident, a back and forth, I submit there'd be more injuries to her front, injuries that could be described as defensive in nature, and they just don't exist here, at least not in my recall of the evidence. We know that she's bleeding a lot in that kitchen, again, as evidenced by the photos that we've all seen. And there's been testimony by the expert Klein who indicated many of those would have resulted in death. I don't recall that he said specifically which ones, but he said that there were various injuries that she sustained that could have resulted or would have resulted in her death. Now, again, I hate to be redundant, but why I come to this conclusion, why I submit that's the case to you, is just the sheer volume of blood. And she's intoxicated, so she's going to bleed a little faster. If any of you have ever been under the influence and bled, even just a small finger prick, you bleed a little bit faster, your blood's a little bit thinner. And again, the knife and the screwdriver were located there. I submit to you the incident was very short in duration. I know that there's an argument to be had that maybe it took a lot of time, but I don't think the evidence supports that. I think it happened very, very quickly. Because had she have been screaming, had this have been carrying on, I think it would have got someone's attention. The downstairs neighbor heard a few things, but nothing that got his attention. I think he put his headphones back on and continued listening to his TikTok videos. And I don't know if there were other residents, but this was a fourplex, so there were at least 2 other apartments, whether they were vacant or not, but none of them testified if they were even home or awake. But had this have been an elongated situation, I would imagine somebody would have been kind of, I guess, aware of it. Again, this is why it's difficult to kind of talk about, because this sort of notion of adversity. I think the incident happened in the kitchen. I think she died in the kitchen. I think that that's what the evidence supports. I think it happened fast, and again, I think it happened in the kitchen. I submit that to you because I don't believe the evidence supports she could have gotten anywhere else under her own power, based on sort of what Dr. Klein had testified about. And there's no blood pattern, which is a little, maybe that's not unusual, maybe it is, I don't know. But there's blood in the kitchen, and then there's not really any blood till she's at the doorway. I can't make sense of that unless somehow she were moved, which maybe doesn't make a whole lot of sense to you. But if she were walking or crawling and actively bleeding, there'd be a trail, and it just doesn't exist. I think the only blood between the kitchen and the living room was like a smear or a brush on the recliner, which could have very easily just been Behal when he passed through. Now, any offenses that occur after someone is deceased is not murder in the first, murder in the second, voluntary or involuntary. It's just not. You can't form intent after the fact. That is a separate crime and a crime that has not been charged. That is an offense with, it's referred to as abuse of a corpse, which basically means that there's damage to a dead body. That is not any of these offenses. That is a separate offense, and I believe something happened, obviously, by the door. I think that there was like some spraying, if you will, or like, I don't remember the term that they used, but there was evidence of blood like on the door. But again, I submit to you, she was long dead at that point. Maybe long's an inappropriate word, but certainly already dead at that point. And I come to that conclusion, or at least I submit to you that that is the case based on reason and common sense, because there's very little blood found in front of the door. If any of you have ever done any plumbing at home, you're kind of familiar with this concept, which is if there's a break in a pipe while your water is on, right, and by on I just mean the main is open, you could flood a basement. Like, it'll just kind of keep coming and coming and coming and coming. But if you have that same break in the pipe and you turn the water off, right, it'll still come, but only whatever water remains in those pipes, right? Maybe that doesn't make sense to those of you that are familiar with it. It will make perfect sense. The idea being you don't continue to bleed after you die. I submit to you that the very small pool of blood that exists near the doorway is just gravity taking place. It's just whatever residual blood comes out post-mortem. Reasonable doubt. The state is burdened with proof, so I just ask that you make them prove it, right? It's really that simple. That is my ask here. Instruction 42 indicates that your sole duty is to find the truth and to do justice. That's your job. You, I think, will have a natural inclination to blame. We talked about this a little bit during the jury selection process. It's natural. We all have it. And you can still blame him under the options that I submit to you that you have available. You can blame him for everything with the options that I submit to you remain available. I just ask that you only convict him to the degree that he is legally culpable. That's all I can ask you at this time. And with respect to the verdict, I just ask that you find him guilty of voluntary manslaughter under count 1. And again, I submit to you the basis for that is the fact that he was stabbed first. The evidence supports that. There was no stabbing after she was struck. I submit she was not capable. So she stabbed him, and he acted out of impulse. And that is what the evidence shows, and that's what I ask you to find. Thank you.